because it's less about Glen Campbell than it's about your opportunity to learn about how to plan your own affairs from the mistakes or the good decisions of others.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by Tucker Allen. Here's attorney CPA Joe Cordell.
Okay, today we're picking up with part 2 of the episode we're doing on Glen Campbell's life and his estate. I hope you enjoyed part 1. Here we go with part 2. Glen Campbell amazingly managed to have a positive relationship with of the 8 surviving, 5 of them, and these 5 were named in his will. His wife was named executor. The will was created in 2006, so it was before the Alzheimer's diagnosis, but we can assume that there would have been some early dementia, certainly in 2006. I mention that because the 3 kids who were excluded from the will, when Glen Campbell did pass away in 2017, they did bring an action challenging the validity of the will, alleging that he wasn't mentally competent to create a will. He didn't have testamentary capacity, is the phrase that's used. Now, they lost ultimately, but this was something that probably could have been avoided, and I'll talk about that in a few minutes. But that challenge reflected the fact that there was bitterness on the part of 3 of the kids. But other than that, and that didn't go on for a long time, that challenge was ultimately resolved or dismissed, certainly in 2018, so maybe mid 2018. So there was a will in place that was created. The will didn't have anything strange about the beneficiaries. It's kind of what you would expect, often the wife along with the kids. There is an aspect, though, that's important to understand. If you do the research to figure out what the estate was worth, and this is something that we regularly do, and we sometimes run into obstacles finding out what the value of assets when we know that for the most part, if it's a will, it's going to be available to the public, and we can figure out when they post a financial statement reflecting the contents of the will, which the executor must do. It's called an accounting. Then generally people find out more about estates and about people's assets and their lives, quite frankly, than many people would like for strangers to know. But in this case, the number they came up was shocking because the estimates, according to people who estimate such things, and they generally go by public records of various sorts. What real estate do you own? Do you own shares in publicly held companies, et cetera? And they put together these estimates that we all see of people's net worth. But those can be wildly inaccurate. For example, the people who gather that information, they don't know, if somebody owns private companies, if they're not listed on an exchange, if they don't have to report information to the SEC or any state regulatory organization. So there are lots of ways in which you simply can't get the information that many people would like to have about the wealth of others, about what they own. So you go to these organizations, and the organizations, depending on the asset composition, could be right, meaning if it is these assets that they can locate publicly, if somebody bought something very expensive at an auction, if they bought a $10 million item at an auction, a search, a combing of the web is going to generate that, assuming it was bought in their name. And there are these other 4 or 5 different sources, taxes, et cetera, where you can obtain information, some tax records. In this case, though, the estimate was around $50 million, and it turns out we know what the probate estate was. And it was originally listed at a shockingly low number, under $500,000. And then it ultimately was settled as revised, the value of the estate, to be $1.1 million. So that's kind of where it settled. And that 1.1, interestingly enough, included the intellectual property. So it assigned to, for example, the future music royalties, $1.1 million. So we have an estate, incidentally, that we'll say it's less than 1.2 is what the court concluded after this revision. So 1.1 is coming from future music royalties. And then name and likeness royalties, which, the promotional value of the name for the most part, $10,000. So that tells me that there's probably some fraction of the market or of a market that was excluded from what was transferred previously to a trust. We do know there's a trust. We researched that and we confirm, yes, there was a trust. It was referenced in one of the court documents, but we don't know what was in it. Now, when you have somebody such as Glen Campbell, who has somebody who's very responsible, Kathy, who's taking care of him, overseeing him, he knew he was going to die. He was trying to put his affairs in order, and he was clean at that point. Glen Campbell, once he became clean in the mid-'80s, he kind of fell off the wagon in around 2000 was the estimate, and so it was bad for a period there, a year, 2 years, maybe 3 years. We don't know how long that lasted, but we know that he ended up back on the wagon, and by the time he got the Alzheimer's diagnosis, he was clean and had been clean for a while. So we know that he's thinking clearly as he can at this stage, given where he is. And the probability that he would not have moved things into a trust just seems very remote. And it turns out, yes, there was a trust. And that trust was created in 2006 along with the will, so it was before the diagnosis. But we know that he would have been, certainly Kathy would have been, very fastidious in assuring that this trust was funded. Funded is the word that's used. I don't like to use it, but just because people can't imagine what that means. And all it means is you create this container, this receptacle, and you have to move stuff into it in order for it to be helpful. So that means you have to change the title on assets and other things and let the trust own it. So people who do estate planning call it funding, but whether you call it a funding or something else, the idea is that there were assets of probably the primary value by far of his estate that went into that trust, and as a result would not be listed in probate because it would have bypassed probate. Now, it doesn't mean that these assets wouldn't have been taxed. Unless it was an irrevocable trust, the taxes wouldn't have been paid at that time. So it's probable that there was some tax planning done, but still, either way, there was a trust in which all the assets of real value were probably held. And I would argue that for the name and likeness to be $10,000, we know that the value, what would somebody have paid his widow a week after he died for the right to use his name and likeness to promote? Choose anything, a single restaurant, not to mention a company with a bunch of locations that might have had appeal to people who liked Glen Campbell. $10,000 right there. You know what I'm saying? For a year, not to mention forever. So for us to believe that represented all the rights relating to his name and likeness is crazy. $10,000? So we know that however it was defined, there was some reservoir of value that wasn't included in that transfer to the trust. So the name and likeness, the 98% of that value, some substantial part of the value is in the trust. I'm confident of that, though we can't verify it. And then also, what about the royalties? Well, the royalties those rights will continue for an additional 70 years from the time of the recording's release. So 70 years is a lot of income that would still be coming for some big hits. So we know the value of that. If you look at all those hits, all those albums, all of them, 1.1 million cannot capture all of that. So I'm confident that some of those royalty rights were transferred to this trust. So this is the one reason you want a trust, is you do have privacy, and it also can give, if done properly, can give some tax benefits, but that's typically an irrevocable trust, and I'm not persuaded he did an irrevocable trust, but I am persuaded that there was a trust and that he probably had a whole lot more value. He had to have had a whole lot more value than $1.4 million. It just had to be substantially more. Now, that's not to discount or to push aside the fact that he lived this dissolute life for a number of years and made a lot of bad decisions. I don't doubt that his estate is worth far less than it should have been, which is a theme that we've echoed more than once on here, is, it's amazing the impact that divorce has. And I come back to this not because I choose to bring it up, but because it seems to linger over the financial affairs and the estate of lots of successful people, celebrities. And it's simply a lesson that bears repeating. And even if you're not rich, even if you're not famous, it bears repeating. That divorce can be a very expensive thing, regardless of your net worth, because it's still everything that you own. So to lose presumably half of that is a blow. So if we do the math here and we look at each of these divorces, there were 3 divorces, 4 marriages, and assume that at each one of these, it's like you've gotten to a certain point in terms of progress of your balance sheet or your bank statement. You get to a certain point of net worth, and then you slide back down the hill, about halfway down the hill. We'll define it as half. And it could be more, could be less. Typically not more, and it could be less, but it could easily be 50%. So you slide halfway back down the hill, so you get married again, and however long that marriage lasts, then there's a divorce. You slide halfway back down the hill from where you were. And it's a process that is magnified by maintenance. It's magnified by child support payments and all the inefficiencies that go with that, which we've talked about, I think, on the last show on this subject. And when I look at things that should be done differently about Glen Campbell's estate, I praise the fact that he created a will that does the job. It wasn't designed to create conflict. It was a predictable allocation among beneficiaries. The fact that 3 kids were left out, it was explicit, which it didn't look like an oversight. That's the better way to do it. So there cannot be someone who challenges the will based on what they think is a mistake of fact or mistake of law even. So that's something that needs to occur, is that you need to either do what would otherwise be a predictable allocation of your assets, or have a meeting in which you fully disclose the fact that you're going to do something that would otherwise shock at least the people in your family, and explain it. That's going to dramatically reduce the chance, not eliminate it, but reduce the chance of conflict. A thing, though, that he didn't do that I think would have been better would be to have a provision to give something even to the kids that are being disinherited, just enough to where they have a reason, a disincentive to challenge the will. So if they don't have any disincentive, in other words, if you've left them out entirely, then to do an interim clause, or a clause that says if you challenge this will in any way, you forfeit your interest. Well, if you have no interest, there's no disincentive. In this case, there could have been an inclusion of something so that they lose it if they challenge it. Something more than nominal but not substantial would have been sufficient. So that would have been easily fixed. It may not have prevented what happened, but often it does. Another thing, though, that I think is that obviously all the royalties were not sent to the same place, because we had this $1.1 million. So I'm betting there were perhaps contracts for payments of royalty with different publishers or distributors or recording studios, whatever it was. So my guess is that the one was left out of the trust, maybe for good reasons. It could have been that it was an oversight, but sometimes you'll choose to keep something out of the trust, especially if it's going to be an irrevocable trust. And you may want to have the versatility of doing something different with it later, and maybe you plan to do that before you die. Sometimes when you transfer something to a trust, it can trigger some sort of clause, like a due on sale clause. So if you've offered this contractor these rights as security for a loan, and you transfer it to another entity, unless you get special permission, then usually a due on sale clause would be triggered, and as a result, that whatever that loan was would have to be repaid. And for that reason, sometimes you'll have big assets like a house that has a mortgage. Sometimes people don't put the house in the trust. I always argue that if you go to the lender, especially if it's a local lender that keeps the loan in-house, you always get approval for that, because it doesn't increase the risk. This is a trust that is it's kind of like a shadow trust, it's called, meaning that it's fully revocable, so it has no tax impact on you, and in no way is somebody's loan jeopardized because you've transferred it to that entity. And you can even amend the loan documents to be sure. So Maybe that's what was going on, that they kept these assets out of this trust. We'll never know that, but I'll just impute to them that maybe they had good reasons to do that. I'll just mention again in passing that I think, one of the things that would have contributed most to this estate would have been better handling financially during the course of Glen's life. But that's something that you have to take the hand that's dealt you, and whatever assets were left, I'm sure they were substantial, despite the fact that they were far less than they could have been. Another thing that I would mention in terms of planning for this estate would be that the wife was named as the executor. So it did set up a potential conflict with the kids. Now, there's nothing wrong with naming a spouse as what would affect a stepmom to your kids as the executor. A lot of people always want to name their spouse an executor. But you do need to know that there can be some conflicts of interest when it relates to not the kids of your current spouse, but the stepkids. So in that traditional nuclear family where all the kids are the children of both the mom and dad, then to name the executor as a surviving spouse is perfectly understandable, especially if they understand their responsibilities. But when you have kids that are from prior marriages, then you're really asking this executor to perhaps be more fair than chivalrous even than they might be capable of being, particularly if there's bad blood. Now, in this case, there was a bit of a dispute over the debts that the executor claimed were due, and these were submitted by the executor as debts that were owed to her. So in this case, Glen's widow, Kimberly, she asserted that there were 5 separate claims totaling over $1.3 million against the state. This would essentially have wiped out anything that anybody gets. Remember, the way an estate works is that creditors have to be paid first. So the responsibility of an executor, among other things, is to, number one, marshal all the assets. That means identify all the assets, to inventory them, to take possession of them if necessary to assure their safety and protection. So that's number one. So number two, they have to identify who the creditors are, which typically involves a couple things. Things are posted in legal periodicals in which this article or this posting will state that there's an estate of so-and-so and you have so long to come forward and assert your claims, typically 6 months, but you'll have a period of time to come and submit your claims. And if the claims are legitimate, of course, they'll be paid. But the point is, any debtor, any legitimate claim is to be paid in advance of distribution. Remember, kind of the you might think of what beneficiaries get as kind of the residue after all the expenses associated with the estate, after all the payments that, remember, an executor or a personal administrator, same thing. In some states you call an executor a personal administrator. Most states, in fact, now, including Missouri. So the personal administrator gets paid very generously, so that's not cheap. That money comes off first. And then the claims of being creditors. And then the creditors, you have a tiered scale in which IRS gets paid first, state claimants for taxes, any state agency gets paid. There are a number of priorities that exist. Support will get paid before just a general creditor. So finally, after you go down these tiers and all these claimants are paid, only then with what's left is there a distribution to the beneficiaries. So in this case, and I'm not questioning the legitimacy of this because I don't know the legitimacy, and I'll even assume that there's some merit to these claims, but yet I see how it sets up questions in the minds of the children, especially the children that are not Kim's children, which would be 6 of them, although not all of them were legitimate beneficiaries. Anyway, so if these claims that she asserts here are paid, then it means that these kids get nothing out of the probate. Now, keep in mind, there's a trust, and the trust may provide generously for everybody. So I don't want to make too much out of this. But I think for us to learn something, though, we can ignore the trust. Just forget the trust is there, because it's less about Glen Campbell than it's about your opportunity to learn about how to plan your own affairs from the mistakes or the good decisions of others. And in this case, this commonly happens that you have somebody who's kind of running the probate process. That's the primary responsibility, is the person that the court appoints, which will be the executor or personal representative, and they're making all these decisions. And the children, while they have a right to file a complaint with the court, they have a right to bring actions. For the most part, they're in the back seat, and they're a bit of a spectator through all this, and then they end up questioning very often how little money they got and whether there was something that was done that wasn't fair by the executor, who, remember, they don't like anyway because it's their stepmom. In this case, there's $330,000 for medical expenses, $506,000, which is the largest single claim. I don't see what that is for. $300,000 for reimbursement to pay off a mortgage on a California property, and then $175,000 payment from a joint checking account. Apparently, that was money that should be replenished to the joint checking account. We don't know more than this, but we do know, and then there are unspecified credit card charges to be paid. But we do know that this never goes down well with stepkids, and especially when it wipes out what they would have gotten. And if we assume that there's not a trust with a bunch of money in it, then this is it. So we can be sure, though, that these were challenged, and probably by stepkids, I'm guessing. So a special administrator was appointed, Blaine H. Smith, and the challenge was against 5 separate claims of those items I just mentioned that totaled $1.3 million that Kimberly had filed. So I don't know what the special administrator, whose job it was to determine fairly whether these were legitimate. So somebody must have filed an objection. And we don't know what the ultimate ruling was, but that's less important than for you to know that this was a problem that developed, conflict that developed, that could have been probably avoided if it had been handled differently. If there were a different executor, it would have caused less distrust. And were there legitimate expenses, then Kim could have submitted those. And then you have an independent third party who's assessing the legitimacy or the value or the worthiness of these things. So I'm sure that was the reason that there was a special person appointed, and whatever their decision was, you can bet it didn't make everybody happy. So that's something I would point out as a factor to consider as you think about your own estate. And then I had a couple other items in wrapping up here. We talked about the drag on the net worth associated with drugs and alcohol. Huge drag, but that's multifactorial. That encompasses a lot of stuff that's just hard to measure. You just know that people who spend a life with drugs and alcohol problems, it's never good for their estate. We mentioned divorce, alimony, the fact that we have a trust, which was probably funded after the diagnosis of Alzheimer's. That's not perfect. To the extent that there are going to be challenges to transfers that were made, those become a little more vulnerable because they're made after somebody is known to have Alzheimer's, as opposed to the will. The will is made in advance of the diagnosis. It's 06. Was it 06 or 04?
06.
06. So the will was made in 06. So the diagnosis was around 2010. So, you can say that there was a little dementia, but it's a point in time where it's very early. The thing is that even if you have marvelous estate planning and you're perfectly clear on the occasion that you do it, or let's say passably clear on the state you do it, meaning you have what is testamentary capacity, which is a really low bar. You don't have to be sharp as a tack to do a will. As a matter of fact, it's one of the lowest standards of mental capability in the law. Believe it or not, there's one lower. Do you want to guess what that is, Marley?
Isn't it marriage? We've talked about this before.
Yes, we did. That's good. Marriage. Well, I mean, if you think about it, at first it seems crazy, but if you think about it, the law is reluctant to deprive somebody, even if they're challenged cognitively, of the right to be married. One of those fundamental things about human existence, a relationship with another. So for that reason, the law has set a really, really low bar in terms of mental capacity in order to get married. So rarely does somebody deny the right to get married. In this case, though, this is a very low bar, testamentary capacity. so you get past the creation of your estate plan, marvelous. But if it's going to be an ongoing sort of process where you acquire assets or assets come into your possession, maybe you inherit something, then it has to be transferred in. If you're the one who is the trustee, and that's the norm, we don't know that Glen Campbell did it this way, but often when you create a trust, you'll be the trustee. So you need to be sure you're no longer the trustee if there's any vulnerability that your children or a third party is going to challenge whether at that point in time you were competent. Not when you created all of your estate planning. I mean, you could have been clear as a bell then. The issue that will be attacked is the assets that you moved in at that time. They can challenge that particular transfer as opposed to challenging the estate planning itself. So in this case, we don't know when assets were transferred into this trust. If they knew there was this diagnosis, they're probably rapidly moving them into the trust. One reason that we didn't hear an attack specifically on that was that even if these 3 disinherited kids were to succeed in saying that these transfers into the trust later of assets were at a time when Glen Campbell was not competent to do that, it would have been a Pyrrhic victory, because where would they be? Well, they'd be that they'd be outside the trust. They'd go through probate, which is not a happy thing, but they end up with the same people, assuming that the beneficiaries are essentially the same. They probably were or similar in the trust. So to move it from the trust to the will, it doesn't accomplish it. That's probably the reason there wasn't a fight on that point. But had there been a dispute among the stepkids, the other 5 stepkids who were provided for in the will, but they didn't like the distribution, for them, if the distribution was more advantageous with a will than a trust, then they would have every reason to challenge that transfer into the trust and try to keep it available to go into the probate estate because they had a better allocation. So we don't know if the trust was created primarily for the benefit of the wife of his surviving widow or not. But there are a variety of factors that can incentivize somebody to challenge the transfers into the trust later, is my point. So just not being too picky here, because I think that Glen, the people around him, did a lot of things right. There's not a whole lot to criticize in terms of just the estate planning itself. We talked about the widow's claims, the fact that in this case we had another administrator appointed to resolve that dispute. The calculation of intellectual property by the probate court, I won't go into that, but we'll save that for another occasion to talk about how this is valued for purposes of the IRS. But that's always something that is a vigorous source of dispute and a worthy thing to challenge if you're an executor of an estate and your job is to maximize the amount of money that's available for creditors as well as the beneficiaries. And in this case, any case in which you have intellectual property, I mean, you're looking at how do you value the royalties and how do you value what's left, which would be, say, name and likeness, kind of this other category of regular sources of revenue after death. That can be more than the royalties, depending on how successful your music was or how long ago it was recorded. But this valuation process is a battle of experts, and it behooves anybody who's an executor for such an estate to hire talent, and there are firms that specialize in this, and they go to battle over it. And sometimes it ends up in court, and it's not unusual for the estate to win, meaning that this value that's assigned by IRS to what they think is going to be income going down the road, it ends up being unfairly large. So there are huge discounts entitled for certain things. Now, sometimes there are things that can happen where it actually increases the value in the short term. They talk about this surge that occurs upon someone's death. So it is common for a value of an artist to go up immediately after their death, and then the dispute becomes, well, how long will this elevation in popularity last? And we know for some, it's still lasting, and they died in the 70s. Janis Joplin, we've talked about some of these. But others, it's kind of a blip. It goes up, it's there for a while, and then it collapses soon thereafter. So for the IRS to impute something long-term has huge consequences. You can't go back and change it. I mean, once the projection is made, it's not as if it turns out to be correct, you could go back and change it. No, it was considered a reasonable estimate at that time. Whatever events occur later, you don't get to go back and decide that the IRS owes you a bunch of money. Just like the reverse is true. Let's assume that you get a valuation of $1 million, and it turns out that it was worth $50 million for some reason, like Elvis Presley or whatnot, where it wasn't anticipated. Well, the good news is the IRS can't come back and say, gee, we made a mistake or we undercalculated it. No, they have to live with that. But it is a two-way street. You have to keep that in mind. So this isn't a subject that I realize many of you deal with, but it is an interesting topic. And we'll spend more time talking about how these calculations are made. It's really interesting stuff, and it can be easily 80% of the value of an estate. And I'm sure in this case, it was 80% of the value of the estate. We just don't know what that is, but I would suspect it's closer to a lot closer to the $50 million than it is to the $1 million that was the probate valuation. Anyway, so with that, this has been another episode of Life's Third Act. Hope you found it interesting as well as helpful. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement. Sponsored by Tucker Allen, your estate and elder law advisors. Each week we discuss topics and answer questions to help you better plan for your future. For more information, visit tuckerallen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.